Welcome back to Citizen Gumshoes. I promised, like I did before, to read out the transcript, the latest docket that I've retrieved of Puff Daddy, aka Sean Combs, and it's a transcript of what's happened in court lately. What the bond appeal was and what they spoke about in court. And this is a new document. It was filed on the 18th of September. Okay. Now I'm going to read through this and go through the interesting parts, so it saves us time, okay? Now the government testified on behalf of the state. And they say about Combs, the physical violence and sexual violence has gone on for decades. The very conduct he's charged with shows his dangerousness, his resources, and his willingness to lie and obstruct. Defendants electronically recorded the freak-offs, and he did that at least in part so he could keep the recordings and use them as blackmail against his victims. So I want to pause on that for a minute, he says. In 2015, when a different victim said, and here's a quote, "He's just threatened me with about my sex tapes that he has of me on 2 phones. He said he would expose me. Mind you, these sex tapes, where I'm heavily drugged and doing things he asked of me for the past 3 years. This could be Richards talking. At least a dozen witnesses will confirm that they personally observed the defendant's violence towards women and injuries that were sustained as a result. The defendant surrounded himself with and used firearms, including 3 defaced AR-15s and a high occupancy magazine loaded with 59 rounds of ammunition that was seized from his LA and Miami residence this year. What you gotta ask yourself with is, why is he using defaced firearms? According to this docket as well, all his own security had their own licensed firearms. So these firearms were Combs. They were used for illegal activity and also possibly to get, knowing someone's got a gun in their possession and they're making you do all these things, you wouldn't think twice that this person's not going to use a gun on you, The next part. They were stored in the defendant's home, but it's worth noting that the defaced guns have nothing to do with the security and have everything to do with dangerousness. One more point on this is that the security team is now the same team he suggests to be allowed to monitor him while on bail. Now, the problem with that is, with him being a flight risk as well, these people are going to be pressured under circumstances like when he's on bail to possibly let him go and take a flight out the country, What he did to Cassie, he cast it as a misdemeanor assault arising out of a lover's quarrel based on the fact that he wanted to get his clothes back, but that's not what happened. So according to him, she took his clothes, and that's why she left. Also, we heard from Lamisha, who's lying her ass off, that Cassie possibly had money in them bags as well. She was stealing from him, but she wasn't. Why would she say something like that about a victim? It's just bizarre. I feel that there's something going on here, a little twist in this, and he's causing this chaos because he's part of that cult, isn't he? He's gonna cause chaos in this case as much as possible, with people pretending to be victims and things like that, wasting people's time, and it's worked to a point. After the assaults, because that's when the cover-up started, the security guard refused to be bought. This is in the hotel. Then the defendant's staff got involved, contacting the hotel security to get the footage of the incident and keep it from being seen by anyone. The defendant was just trying to prevent something embarrassing from coming public. Now, this is the things he was saying to Cassie at the time of the incident. Call me. The cops are here. I've got 6 kids. Yo, please call. I'm surrounded. You're gonna abandon me all alone. While we don't have evidence that the police were actually there, the point is that the defendant knew he had done something that could be elicit a law enforcement response. And he had to cover it up. And critically, his staff knew that police had responded to the victim's apartment. They have photographs of the responding officers' Los Angeles Police Department business cards in their text messages. So Caassies took a picture of the business card the police have when they visited her home, and the staff members remained in contact with the victim to ensure she would not talk to the police. It's a result of the defendant's cover-up continued until last year. So he was covering up till Cassie filed a civil complaint. By the defendant being hit. This is what he said was what happened from the defence. From Diddy's point of view, this is what happened that day. By the defendant being hit on the head while he was sleeping by a cell phone and his clothes being taken in a small overnight bag that you can see the victim walking down the hall with, in addition to her purse. That's what he's trying to say she has on her, that his clothes were in the bag and he saw his ass. Assuming, for the sake of argument, that it did, which it didn't. And if it's about the clothes and wanting to get the clothes back, which again it's not, why drag the victim back down the hall to the room? And it states the government says, and as I said yesterday, it is really important to note that long-term relationships and abusive relationships are not mutually exclusive. He argued in essence that anyone who was participating in a freak-off wanted to be there. Evidence shows that there is a risk of physical danger towards victims, employees, and other individuals. They sometimes occurred in cars where victims' heads were slammed against car windows or on the floor of the car. And here's a quote from what Caassies, or one of his victims, have said: "When you get fucked up the wrong way, you always want to show me that you have the power and you knock me around. I'm not a rag doll, I'm somebody's child," she says. The defendant's violence was premeditated and spontaneous, and I think the text messages highlighted that. How do you craft bail conditions that can address the defendant's tendency to become violent at the slightest provocation? You can't really, can you? You can't say, he's spontaneous and premeditated, all in one ball. The willingness to strike a loved one is evidence of a tendency to be violent and dangerous towards others. That's a very good point, because if you're violent towards your loved ones, I guarantee you've got a short temper with everyone. They might not show it, but they'll take it out on someone around them. It's bizarre. Witnesses have universally, one for one, expressed to us their extreme fear of the defendant is extreme. His influence makes it so difficult to convince witnesses to share their experiences and to trust that the government can keep them safe from him. He and his co-conspirators continued their efforts to reach out to potential victims and witnesses. This outreach has included directly contacting at least one victim in November 2023, constant contact with witnesses to the charged conduct, and with contacting witnesses including those who received a grand jury subpoena, which you're not meant to speak to people who've got that. And this contact is as recent as July of 2024. These communications are both prior to the following the witnesses meeting with the government. So after the meeting with the government, he's getting in touch even. And the government has evidence that the defendant knew that this witness had received a grand jury subpoena. And after the meeting with the government, there were 14 total contacts between the two of those people. What that means is going to be explained. There are 14 total contacts between the defendant and the witness. A witness was served with the grand jury subpoena in June of 2024. Thereafter was contacted multiple times by the defendant by phone and text in June and July of 2024, despite the fact that the two had not spoken for several years. And in an instance I'll describe in detail, he recorded the conversations with a victim on the device of a co-conspirator. Even more difficult to detect when it's being done through other people and on other devices. This is before prison. We know from evidence we've collected that the purpose of these calls was to spread false narratives. So here's the example. Defendant directly contacted the victim in November 2023. He placed 2 calls to the victim, both of which are recorded on the co-conspirator's phone. Probably one of his security team or someone, but he's used 14 different people to contact this victim. He's used 14 different devices. Do you know what I mean? The defendant provides financial support to this person. The defendant received a text from this other person. In response, it reads, and she talks about a trauma and what have you. In those recordings, he gaslit her and he attempted to convince her that she had willingly engaged in acts with him. The defendant assured the victim that if she continued to support him, she ain't got anything to worry about, which is a thinly veiled reference to his continuing financial support, and subsequent text messages make explicitly clear that that's what he was talking about, because 2 days later he texts a co-conspirator in reference to financial support that he provides to this victim and said, make sure that, and he uses the name here, the name of the individual who is his financial advisor, is not doing anything dumb, like not having that rent paid on time. So he was helping her with her rent. The defendant made sure that the financial coercion continued. But the facts of the case are that the defendant contacted the potential witness and attempted to feed that witness a false narrative with the hope that the witness would adopt it as that person's testimony, and that's exactly what's going on here. So he's hoping that she'll change her outlook, basically, on the matter. Now, don't know why it won't let me pause here. Wow, what the hell? Okay. Hang on, sorry. Hang on. What's happened? The government had previously indicated that there was another potential witness that the defendant contacted between September 10th and September 14th a sum of 58 times. Can you give a little further elucidation on that? Asks the court. And the government says, so on the September 10th, so last week, an individual named Dawn Richard filed a civil suit against the defendant and other individuals and entities. Miss Richards was formerly in the band with the defendant and a third individual named Kalina Harper. Kalina Harper released a statement where she, in sum and substance of sorts, says Mrs. Richards' experience isn't what I experienced. But between those 2 dates, between September 10th and 14th, the defendant and Miss Harper had 128 total call contacts. So they contacted each other that much. Bloody hell. He called or texted Mrs. Harper 58 separate times in 4 days. It makes clear that the defendant has an ongoing ability to keep witnesses, even witnesses to very distant abuse and very distant things, in his pocket and at his disposal. He says the defendant is a danger to the community and poses a serious risk to the integrity of the proceedings through his efforts at obstruction. Now Diddy's lawyer speaks. His lawyer states, "She wanted to make a statement. She told me she wanted to make a statement. She believed Dawn Richards' statements were not accurate, and she wanted to say something, yet she didn't want to get overly involved." This is the court asking now. When she told you that? That was either September 11th or 12th, or I believe that's right, the court, which is after the 10th, after the defendant first reached out to her. So the defendant reached out first before his solicitor did. He goes on to say, his solicitor, when the civil complaint hit the news, Kalina Harper, who was in the same band as Dawn Richards, obviously said to herself, "I was in the same band as Dawn Richards. I didn't see any of those things." The court. Hypothetically speaking, if your client reached out to this person on September 10th, hypothetically speaking, right? The court says further, I want you to say this again, very hypothetically speaking. Let's say he did. I want you to lie about what happened. This is what the court are hypothetically saying what happened on the 10th. I want you to tell this story and give that information to her on the 10th. And then the 11th, you get a call from her lawyer saying that she's interested in maybe making a statement. But he's not clear if she could make a statement. Wouldn't that still be evidence of an obstructive mindset of a willingness to tamper with potential witnesses? I'm sure that you're going to say that this person is not necessarily a witness in this proceeding, and therefore I shouldn't consider that. But wouldn't that be evidence of a mindset that's willing to tamper with a witness or obstruction of justice? There's not getting past this court officer. Yes, you might be right. I mean, you wouldn't say that as a solicitor, would you? The reason I wanted to speak to her and Miss Garagos remind me that we spoke to her on the 10th as well, and she's coming with her computer. We are going to get some accurate facts, probably more specific than I'm saying. And then talks about Mr. Grego speaking to her. She's mentioned in this lawsuit 34 times, so she felt that her name was also being, I don't understand, besmirched. forget it. In terms of she had witnessed violent acts by Mr. Combs against victim 1 of count 2. And also, I believe the contact with this potential witness was also a potential defense witness for us to speak to, because she was mentioning violent acts with the respect to the person who is now victim 1 in count 2. So we did speak to her that night because we thought it was important in terms of our defense investigation. So they're going to ask her to be on his side and speak on his behalf, say good things. The court says, okay, but after speaking to defence counsel on the 11th, what would be the reason for her and Mr. Combs to keep in touch? He's got a point, right? What would be the reason? She just was not, this is what his solicitor says, she just was not, that she stated, at least to us, that she was not present for, and that's why speculation. She wasn't present to see what Mrs. Richards was saying about Mr. Combs. This is what she's coming to say. Obviously, she wanted to speak to Mr. Combs because her name was in the civil suit, and she didn't want the name in the civil suit. And she also wanted to say, I didn't see any of these things happen. When he has been proposed bail, these are the conditions that were proposed to the court through his solicitor. That it be 24 hours a day, 7 days a week. They will have at least 1 and probably 2 Sage employees there at all times. They will basically have full control of who enters and who doesn't enter. There will be visitors log that is kept, and that we could have it shared with pre-trial services every week or every day, or whatever we would like to do in those regards. He also stated that Mr. Combs will not have access to a cell phone since he won't have access to the internet. So what I'm trying to fashion is a situation where any witness intimidation, if that is the court's concern, and I see that it is, would be completely nullified. It would be virtually impossible, and Sage would monitor these things. Make sure he doesn't have a cell phone. Make sure that anybody who comes into the house is on a pre-approved list of visitors. When we told the government on April 1st, all those months ago, that we had Mr. Combs' passport, we were giving the government an assurance he was not going to travel internationally, which he hasn't. So back to April 1st, we knew exactly the nature of this investigation, and it turns out that we were right. But the significance isn't that we were right. The significance is that we knew it was substantial. And even in the face of substantial investigation, Mr. Combs surrendered his passport. Now, but that wasn't all. The court. He was 100% aware by April 1st, the proceeding. Just to be clear, Miss Garageous and I flew to Florida. We sat with Mr. Combs in his house in Florida and we said, "You are being investigated." I mean, we were right because we knew what they were looking into. We also knew it because there was a search warrant and the search warrant had crimes in it. So he knew. He knew on April 1st exactly what they were looking into. So he knew the charges that were coming up, that what they were looking for. So that gave him substantial time to manipulate all these people in all that time, in my personal opinion. I think they call it defense lawyer theatre. This is what his lawyer's saying. He really should talk. But it's not theatre at all. It's actually a person showing tremendous respect for the process of showing the court that he has. He can be trusted because we went also on to do is we took the passports of 5 of his family members, and members of his family and friends are here today in the second row. So what he's basically made out to the court here is that Mr. Combs was very susceptible to the fact that he was going to get charged. Now, that's not a good reaction. That's a very telling reaction. And it isn't showing, it's showing a lack of respect for his family, putting all their passports up just to get bail, to have his freedom to piss off. Because he'd fuck off, wouldn't he? We also made efforts to sell his aeroplane, which is in the process. We have a letter of intent to sell the aeroplane. I credit the government for not raising it as a concern, and I think it's not a concern because we're telling it. So it is a concern, or you wouldn't be selling it in the first place. So you have concerns of him leaving, clearly. You're contradicting yourself by saying that. Do you understand? This is what I read into when I used to have a job. I used to do these things. And I used to read transcripts and I don't know what it is, but they said I was very good at it, and I was part of trying to work out what the defense is trying to hide, trying to make us not be aware of. But they're very aware, this court, yeah? A significant thing is we had the foresight to try to sell it. Yeah, good for you, because he would have been off. We're on, I think, the 4th buyer, but hopefully we'll actually sell it this time. He's talking about the airplane. It gets chartered because the plane has to keep flying or the plane apparently starts falling apart. Weird. It's being chartered by other people in a sort of a public way Friggin' hell. Some defendants flee outright. This is something he shouldn't say as well. And some of these cases are distinguishable. The cause, how does that relate to dangerousness? Generally, or danger or obstruction, because it seems to me, this is what the court's saying, that it may, what you've said relates to danger of obstruction. So, if there's something, if a way of him escaping, he would do it. But not in a good way for you. If he's aware of this on April 1st, then again, why is he still contacting witnesses in June and July? It's a good question. I don't know why my phone's doing this. I want to move on from this and look into the response of Rodney Jones' complaint to Grange and I can't remember the other guy, but what they stipulate, the falsehoods of Rodney's claim. Maybe we could jump to the conclusion and have a read of that and stay off from there, I guess.